attorney from the Department of Justice, Washington, D.C. office, who wants to argue in either state or federal court in any state involved in a big immigration case must take an annual 3-hour ethics course. In addition, Attorney General Lynch was ordered to give Hannon a comprehensive plan within 60 days that would prevent an this unethical conduct from ever occurring again. The Judge Hanson also demanded a list of all illegal immigrants given extended work permits, this is in one of the major immigration cases, and said he may release that list to the authorities of the states where those illegal immigrants live, depending on the outcome of the U.S. Supreme Court's review of the case, which is expected in June. So, now, we had a very similar thing. Thank you. We had a very similar thing happen with Judge Jones in Judge Jones in our case. After he issued his bench ruling, he stopped and ordered the court clerk to take a new record, and then went on the record telling the people in the courtroom that he was revoking the pro hoc vici status, which means automatic admission into the state for practice of law for an attorney from outside the state, revoking their automatic pro hoc vici status, and also requiring them to have a hearing to determine whether or not they could follow the rules of the court and the local rules of the court and the ethics. Because he got to the point in the trial, we had a month-long trial over a period of 3 months, and he got to the point that any time they would raise a case or have a long, lengthy letter or long document, he would recess the court and take a bathroom break, in essence, and go read the case. And then he would come out and correct the government and their reading of that case. But the Ninth Circuit, the Justice Department immediately appealed that, and the Ninth Circuit, being completely an unbiased court, tossed that. So I'll start from the beginning and make it fairly quick because a lot of you are familiar with this, but I do need to give the background so that we understand that we're going 2 different directions in 2 different federal courts. Still, as most of you are aware, my mom and dad purchased Pine Creek Ranch in 1978, and we had moved from a smaller ranch in California. We are California expats, for all of you Californians, and bought a ranch in central Nevada, a ranch comprised of 7,000 acres patented land and another 750,000 acres of government, federally administered land under the Forest Service and BLM. And my dad, who had had forest permits before this, felt completely confident that he could deal with the federal agencies. He'd done so before and had done very well with it, so he wasn't concerned, although he'd been warned by the previous owner that there were problems down there. Immediately, the problems began, and a lot of you know some of these problems, so I won't go into the details. But suffice it to say, we went through 3 administrative appeals, one of which Mountain States Legal Foundation carried. We won all 3 administrative appeals, and nothing changed. What they can do is send you a notice. This is what I'm talking about with regard to administrative tyranny. They can send a business, MSHA can send a notice. Any of these regulatory agencies can send an entity or an individual some sort of notice, and under the Administrative Procedures Act, you have to respond to it or accept their decision. And it has really become a racket in these agencies. One of my favorite stories, or most illustrative stories, is one that Danny and I dealt with. And Danny, mostly, I didn't deal with it, but was a case where a rancher in Northern California had a diversion ditch across his private land that they would divert water in and out of a certain channel, depending on the season. And magically, NOAA, an administration or a department that's in charge of the Outer Continental Shelf, had officials that came in, trespassed on his land to find 15 little baby salmon, sent them a notice of a take, and charged them or assessed them $1,000 for each salmon, so $15,000. It was enough to be worth maybe hiring an called an administrative shakedown. And that's what these agencies are doing. That's what they're doing to the mining companies. They're holding them over a barrel. They're holding up their permits, threatening them, not so subtly. And then the money, and Danny's done this research, doesn't necessarily go to the Department of Treasury. It goes to places unknown. It probably goes into an agency slush fund. So this has become a fully practiced racket on the part of the federal agencies, and it doesn't matter which one you pick, whether it's EPA, MSHA, BLM, whoever, they all do the same thing, and I think they go to classes on how to write administrative letters. So this family, my family, not unlike a lot of other ranchers, it's just that our story is just a little bit more notorious, has gone through, in the last 40 years, 3 administrative appeals. We have had 3 federal court cases in 2 federal courts, and also went through a major water adjudication in the state court of Nevada. 1 family, and we're still in court. In one grazing season, we received 40 certified letters and 70 site visits, personal visits from a Forest Service official, usually packing a gun at the ranch, in one 105-day grazing season. Finally, in 1991, the government, in the first Bundy raid, in the first raid of that sort, they came with 40 armed paramilitary type, they were all swatted out, I guess is the way to put it, and raided the ranch and basically did a civil asset forfeiture at gunpoint, no due process of law, no court hearing, simply a few notices saying that we were in alleged trespass, and came and stole the cattle, and then sold them and kept the proceeds. So that forced my parents to liquidate the herd because they didn't want the Forest Service to steal the rest of the herd. There was a 20-mile unfenced boundary that those cattle naturally drifted back and forth over. There was no way to stop it. So they liquidated the herd and filed a Fifth Amendment constitutional takings case in the U.S. Court of Federal Claims. That case has wound its way through the court. It had 2 trials, one 2-week trial for the property phase to determine what it was that we owned. And keep in mind, for all the attorneys in the room, the only property at issue was on the 750,000 acres of federally administered land. So it included vested water rights, range improvements, easements, roads, rights-of-ways, pipelines, and so forth. Had nothing to do with the patented land. Finally, the court issued a ruling recognizing our vested stock water rights, recognizing our 1866 Act ditch rights-of-ways, our range improvements, and a forage right. Then in another 3-week trial, we went through the takings phase to determine what it was the government actually took, and then there was an assessment on the value of that. And at the end of all of the trials and hearings and so forth in the claims court, we ended up with a little bit over a $4 million judgment against the government. And by the time it had wound its way through the court at that time, it was at $14 million with interest, and plus attorney's fees on the top of that. That case went up to the Fed Circuit Court of Appeals. The government appealed it. And the Fed Circuit reversed in part, upheld in part, and remanded the case back to the back to the trial court. By this time, the Obama administration had forced off judges in early retirement, contrary to what and I understand, by the way, Senator Cotton has rectified this, and these judges are now back on court, as I understand it. But so our judge that had been involved in the trial in this case and had actually done a site visit at the ranch was off the case. One of the things that the Fed Circuit found was that they made a finding of futility, that the judge's finding of futility was erroneous because we didn't get a permit to cut wood out of the middle of our ditch when we had to clear trees out of the middle of our ditch in an 1866 Act ditch right-of-way. They disregarded the fact the judge had done a site visit, that the judge had sat through 5 weeks of trials on the case, heard multiple witnesses and multiple testimony. They also found that part of the case was not ripe, but a major portion of that case was not appealed, and that included all of the rulings on the property rights, and it included the physical taking portion of it. So the case was remanded down to the trial court, and the judge there, a new Obama appointee, Gary, who came out of the Environmental and Natural Resources Division of the Department of Justice. She probably been tripping over our file boxes. She just dismissed the case altogether. And so that case now is back up on appeal, and I have the appeal for anybody who is interested in it, is back up on appeal to the Fed Circuit, raising the issue of, one, that a major portion of the case was never appealed by either party, and the court didn't rule on it, and that would deal with about half of the value of that judgment on the physical taking side, the ditch rights of ways and the physical blocking of the water coming to the ranch for irrigation purposes. The other issue that the Fed Circuit addressed was the issue of access, and they very clearly stated that access was a component of a stock watering right. Remember, a lot of our waters are 80 miles from the home ranch. A lot of our waters, and Rachel, where's Rachel? She lived, and Julie lives 20 miles up the road from us. They've ridden this country. A lot of our waters are up on a 12,000-foot mountain on one side, 11,000-foot mountain on the other side. The only way you can access that water is for a cow to physically walk to that spring, use it, and go wherever she goes to graze. There's no way, as the judges always ask, to stick it in a pipeline and avail of it at the ranch itself. But they said that access was a component of a stock watering right. So that case is on appeal, trying to resurrect at least a portion of that judgment, and most importantly, that access right to water. Now, one of the issues raised in that court was the Judge Smith did not find in the takings case that we had had a taking with regard to the stock waters because of a cancellation of a grazing permit. And we argued that if we didn't have a grazing permit, we would not be able to access those waters because the government would trespass us for using those waters without a grazing permit. But since there had been no harm yet, the judge couldn't make that finding. Fast forward to 2007, my father, my mother, my stepmother had all passed away by this point, and I think they felt my brother was young and dumb, and so they decided to come after him with a trespass case after having threatened to for a long time. Fast forward, in 2012, as I said, we had a month-long trial over 3 weeks and over 3 months in Reno, Nevada. The trial got rather interesting about the 19th day. Danny, you sat through most of it, so I think you're the only one here and Angus, of course. And Angus testified. And about the 19th day, the judge stopped the trial and ordered the BLM manager and the forest ranger to hire criminal counsel to protect their Fifth Amendment right against self-incrimination. At which point, a dear friend of ours called all the folks in Nevada Cattlemen's Association who frankly just didn't understand what we were doing and thought we were outlaw ranchers, and got a few of the president of Cattlemen's and some other people down there, and they were there for the bench ruling. The bench ruling was pretty interesting. The judge spent 3 hours of court time, and for all you attorneys, this may be relevant to you or not. 3 hours of court time reading the 8 published decisions of Judge Jones into the record. Judge Smith, we had Smith and Jones in our case. Judge Smith from the claims court into the record and adopting the claims court findings, as his own in almost every instance, based on what he saw in that trial. So we have 2 chief justices of their respective courts in cases that are separated by a couple decades over a period of, across the span of the entire country, 2 separate courts, making basically the same exact findings as it related to the government's actions and their treatment of our family. Then he went on to make a finding of conspiracy, that they had conspired to take our vested stock water rights and that they had, and our grazing preferences. To give you an idea of the length they went to do some of this stuff, the best example was they had sent about three months before the trial a letter to all of the ranchers who had a grazing permit in the N6 grazing district. You guys, some of you might have got one of those. Soliciting them for, to apply for the Ralston Valley grazing allotment. And all of our stock water. And so this was 3 months before the trial. So anyway, he also made a finding of racketeering, that he found evidence of racketeering, a finding that the conduct of the agencies had shocked the conscience of the court. He said that twice. That's a finding necessary, as I understand it, for a Bivens action. Then he found evidence of fraud, wire fraud, and mail fraud. He also found evidence of contempt of court during the course of the pendency of this case, up to and including witness intimidation and showing up with guns on there, with some agent with guns, and they'd sit there and try to serve somebody instead of send it through the mail. And then went on to make findings about the ranch. He basically had, all these western ranches on these western federally administrative lands are probably down, if they're not completely off the allotments altogether, they're down to a quarter of the number of cattle they used to run out here, cattle and sheep. Folks, we are a shell as an industry of our former self. I was just driving through Nevada after all these rains, and we have feed this high going through good portions of it, and there's not a cow or a sheep to be found. They have destroyed our industry. So he basically ordered them to, one of the things they had done is canceled our grazing permits, and we had tried to apply for them again, and they denied that, arbitrarily and capriciously. When they confiscated our cattle, the judge asked them a question, asked the forest ranger a question: did you actually go back and study that range to see if it had been truly overgrazed, if it had been come back after you removed the cattle off the range? And they said no. They said that in order to access our stock water, that what we could do, we couldn't trespass across federal land, but we might be able to drop a cow from a helicopter maybe down, and if she just puts her nose in that water but doesn't put her feet down, that's okay. That's not trespass. So they basically were denying any access to the water itself. And of course, we had all of that as vested water rights. He found a half-mile forage right around each and every one of those springs and waters, and made some other findings relative to the ranch. In other words, he restored the ranch to its original operating order, ordered us to get a permit, ordered the government to grant us a permit. Well, we appealed to the Ninth Circuit, and as I said earlier today, if you've ever gone into a buzzsaw, that's kind of what happened. That court was hostile from the moment we walked in. And as I said, the Justice Department attorney in both appeals, because they brought in their appellate level attorneys, appeals to the Fed Circuit and appeals to the Ninth Circuit, the same attorney got up and started misrepresenting the facts to the judges and the law. In the claims court case, she said that we had gone to clean up our ditches with heavy equipment, and we had raped and pillaged, in so many words, miles of country trying to clear our ditches. But she also said that we wouldn't have needed a permit had we gone up and just cleared that ditch with hand tools. Interestingly enough, that's what they did do, is use hand tools. So based on that lie to the Fed Circuit, and this is one of our issues on appeal to the Fed Circuit Court of Appeals, is that fraud was committed upon the court, and that they erroneously found against us because of a lie perpetrated by the Department of Justice attorney. So the Ninth Circuit, within a matter of a couple months, I guess, after we had that hearing, handed down a ruling in which these two Obama, one Clinton justices found that Judge Jones in the federal district court had bias. And that was their way to get around the findings of fact from two chief justices of their respective courts over a period of years, after multiple weeks of major trials, is to just make a finding of bias against the judge himself. They ignored the findings of fact, they ignored the law, they didn't even address those issues. Then they said that the only way we could access our water was to put it in a pipe and take it somewhere else. As I said, it's not physically possible. So now, and I might add, with the help of Forrest Lucas and with the help of Protect the Harvest, we have appealed that case to the U.S. Supreme Court. We are waiting to hear from them on the petition for certiorari, and we will, of course, keep all of you abreast of what goes on there. But the long and short of it is that appeal is primarily based on the fact that we now have a conflict between two federal circuits, the Ninth Circuit and the Fed Circuit Court of Appeals, who, with respect to that finding of access to water. This now is important to all of you. This ruling out of the Ninth Circuit hurts all of us, unfortunately. And with regard to water, with regard to ditch rights-of-ways, this ruling could have very far-reaching impact on all of us if it is not overturned. So we are hoping for the best at the Supreme Court. If the Supreme Court does not accept cert, then we have, I think, a fairly good shot at back to the claims court saying that, oh, by the way, you didn't grant us a taking of our stock waters because we had not run without a permit. Now we've run without a permit, and sure enough, they did trespass us, and we now have harm. So this is where we stand right now. The saga continues. We've been at it 40 years, and we'll see where it goes from here. Can I take any questions?
When do you think that you'll hear back? Have you already submitted the appeal to the Supreme Court?
You want my honest opinion? I sure as heck hope in the next session.
What if you were to lie to us?
My trouble is I get a little lippy.
Name, please.
My name is Matt Bush. You said that they committed fraud or whatever, told them that you guys went in with a big heavy tractor, cleared the ditch.
Say that again?
That you went in and cleared the ditch with heavy machinery. Did they provide any proof with that? Or how did that judge make that ruling?
No, we did not use heavy equipment. The attorney testified in the Fed Circuit that we had done that. And to be honest with you, we're sitting here 20 years later in court in the Fed Circuit. We had a little bit of an upset with the attorneys that we had on that case at the time. And nobody caught it. And it didn't even occur to my brother until several months later that we weren't even using heavy equipment. And so part of it is that the plaintiff in this case was my father. And here we are, the second generation, still trying to carry on this case and carry on the history of the case and over a 20-year period, at that time, 25-year period of time.
You good, Matt?
One more. It's interesting that they did not have any proof that you used heavy machinery.
No, but when you're in a 30-minute hearing before an appellate court, you have to respond to that fairly quickly. And frankly, we didn't because it didn't occur to us. We're the kids. I was a freshman when we moved there.
Wow, thank you. One question, congressional or Senate hearings calling the agencies before them to keep them accountable. Has there been anything of that nature in the last, I think, 4 or 5 decades where you got the support of your legislative representatives?
Yes, mostly coming from Utah, I might add. I want to thank the Utah representatives. Your Congressman Bishop held government bullying hearings. And in fact, my brother was invited to testify at that hearing. For those of you who are more interested in this, you might check out the Fox News special Enemies of the State, which covered this whole case on Fox News, and in which those hearings were specifically addressed. So yes, they've done that. I want to also give a shout out to, and he's probably going to address it, Congressman Chaffetz is introducing a bill to address the law enforcement side of this. Remember, they came in with quote-unquote law enforcement to do the raid on Pine Creek. And federal bureaucrats in the BLM and Forest Service specifically do not have law enforcement authority. Every federal land law passed by Congress has specifically reserved police powers to the state, and what they do is misrepresent the Assimilative Crimes Act, misquote it actually, and treat all of these federal lands, for those of you who understand jurisdiction, as an enclave. And most federal land is not an enclave. It's only lands held in proprietorial interest-only jurisdiction, which is basically the same as any other landowner. So in answer to your question, yes, we've had some hearings, but the problem is we've had this current administration that would veto anything that they were going to do. And I have said for a long time, when we get a Republican administration, they better move fast in the honeymoon, because who knows what will happen in the next 2 years in terms of Congress and in terms of the way the Senate and the House work. But we desperately need Congress to intervene on these federal land issues, because as you all have seen on TV, this thing is getting hot, and I am very concerned it'll get worse. And so if we do not get some sort of remedy from Congress, a serious remedy, not lip service, I mean remedy, there are people who are done with this. And as you know, my family, by the way, plodded through the courts deliberately to try to get legal remedy for something that we could see was going to blow up at some point. We knew it was going to blow up years ago. We could see what they were doing to us. They were pushing us to react. They were pushing us to show up to that raid with a gun or something as an excuse for them to arrest my father. Don't kid yourself. They know how to play this. They did it to Kit Laney, and he went there without a witness and lipped off to those people, and that's all they needed for an excuse to arrest him. And they went to the Bundys with a specific purpose to haul him out and his family out in a body bag. And had it not been for everybody showing up out there as basically human body shields, I think that's what Agent Love intended to do. So, yes, there's been help, but it needs to be real help. And I think, as I said earlier, one of the things is dealing with the immunity from prosecution. And I don't mean open it up so you can just accuse anybody of anything and go after any bureaucrat. But I do believe with a high level of criminal intent, for instance, as a standard, or some sort of high level of intent where you've really got a bad customer working for those agencies, where the people who are in the litigation, the private sector is the one that's in the litigation with these guys. The state very often is not. And if we can't go after these people and hold them accountable for some of their conduct, this is not going to change. The culture is not going to change. It is so much a part of these agencies anymore that they do not follow their own laws, much less a court decision. So that's my stump speech on that one. Anyway.
From my friend Tom McFarland, who apparently ate salmon rather than beef.
Well, I told you about round one, Trent. Round one was beef. So anyway, Ramona,
Yes, sir.
most families really, after 40 years, just aren't able to sustain the kind of financial requirement that would be involved in doing that. John Pratt talked about the pond in Wyoming, and what wasn't talked about in that regard was probably the tens of thousands of dollars that would have been incurred in court costs and legal fees to get to that point. Can you give some kind of estimate how much it's cost your family in attorney fees over the course of 40 years? Just some idea?
I don't have an accounting. If you want to count the administrative appeals, they were all about $150,000 to $250,000 apiece by themselves. We had support from Stewards of the Range up until about 2002. We have not been affiliated with them ever since. But it wasn't a lot of support. It was a little bit of support. We had an agreement with our attorneys. It was a bad agreement really for them, and a very unfortunate agreement, that because we all expected the claims court to be much faster than federal district court, including the attorneys at the time. And so they agreed to withhold their collection of their bill until after this case is resolved. It still is not resolved. We have been very fortunate with our current attorney, who was the original attorney on the case, who worked in the Justice Department under President Reagan. He wrote the executive order for 12630, I think is what it is, for takings. He was very familiar with takings law. And he has been very careful with his bill. In this case, in the federal district court in Nevada, on the trespass, my brother did his own. He represented himself pro se because he couldn't afford an attorney. It ended up working out well because he could, and then I was his paralegal / expert, or his witness on the title work, and did the title work and his paralegal work, and because I was cheap. And so we were able to do so much of it ourselves. That really hard physical work with, we had 1,300 exhibits, 500 of which were title exhibits. We did all that ourselves. We had a friend who opened up her house and let us just have carte blanche with the place. And so that's how we've basically done it, by funding it ourselves, by a very good relationship with our attorneys, or who have helped us, or at least signed an agreement with us. It didn't work out very well for them, and we're not in a position to even pay them off at this point. So, but that's where we are.
So I'm curious, do you want to speak to the emotional and family toil that it took?
Well, I could complain, but you know what? I was blessed to have, and my family, my siblings were blessed to have the most amazing parents, and a very wonderful stepmother, if any of you knew her, Helen. And we had a great family. And so, I could complain, but I could have also been born to a crack mother in Harlem. This is our cross to bear. For whatever reason, whatever plan God has for us, this has been our cross to bear. Dad wrote his book in 1990, Storm Over Rangelands. He knew at that time, of course, we were up to here anyway with problems anyhow, so we weren't hurting anything. It was already bad. But that book is in the Supreme Court Law Library, which is always fun to share with attorneys. It's written by a rancher with a master's degree, but 8 copies in the Supreme Court Law Library. And that was a seminal book on Western land law. And it really honestly could not have been written except for by somebody who had an understanding of how these ranches actually worked. And then he had done some work on that in his master's thesis, so he had an understanding of it. But that really brought them down on us. But we knew then that we were in it for the long haul as a family. And yes, it has taken a toll on us. It's taken a toll on some of my family especially. And you can't really quantify emotional issues with these things. It just is what it is. But, I mean, hey, we all have our cross to bear. This just happens to be ours. So.
Rachel Pizzetti, do you have a question?
You mentioned the federal employees and the contempt of court and what the judge found there. Has there been any resolve on them?
Oh, the judge was biased when he found them in contempt as well. They tossed it. So the chain of command in that office is Tom Seeley. Anybody know Doug Furtado? Infamous. It was Ron Wanker who got caught with his granddaughter, I guess it was. Classy bunch. Subsequently, Luders, whatever her name was. We've had some interesting people on the federal side. Listen, we need good bureaucrats. We need good federal employees that are honest and that do a good job and do their job well. But we need everybody to follow the law. What they are doing to us in these industries, and pick your industry, they are holding us to petty tyranny of their rules and regulations, and they themselves don't even follow their own laws as Congress has written them. So that's what we need. We need a change in the culture of these agencies very, very badly. I mean, we can talk about laws all day, and we hope for a land transfer, which would be just wonderful. But until then, we need the culture of these federal agencies to be completely changed, or you're going to see things get worse.
It was my friend Rachel Pizzetti who introduced me to Ramona years ago. We did not communicate for a long period of time. And it was January 9th when I was headed to Burns, Oregon to moderate Tim Smith's community meeting that I called Ramona, and we've spoke 4 times a week, every week since then. And I want to make sure that everybody knows, and I carry the message back east of the Rockies, that this is not about the Hage family. This is about every person in this country that believes in property rights. And that's what Ramona's talking about. All right, Larry, you have the final question for Ramona.
Yeah, excuse me, I'm Larry Williams from Boise, Idaho, and I had the privilege of meeting with your brother 6 or 8 months ago. Anyway, in the process, I looked up the three judges, the three lady judges in the 9th District Court, and all of you should do that and look at their resume, and you would understand that the Hagues had zero chance to win that thing before they ever went there. It was the most, I would ask all of you to look at the resume of those three judges.
Well, and I would add to that, the chilling part of this whole thing is what they did to Judge Jones. It has become apparent that, we all know the appellate courts have been stacked. You know, they haven't been able to do much with this administration hasn't been able to do much yet with the Supreme Court, but they have stacked the appellate courts. Well, guess what? Those appellate judges, those liberal appellate judges, are going after the judges in the lower courts who are causing problems for them. And they have gone after Judge Jones. And I'll tell you what, when that ruling came down, he'd had several other run-ins with him. He is a smart, you know, we had Judge Smith in the takings case, and he was fun to watch, a brilliant judge. Then we had Judge Jones, and I've never seen a smarter judge. He connected dots and evidence and testimony from the first day of trial in March to the last day of trial in June. How he kept track of it all. Busiest judge, according to his clerk, west of the Mississippi. And they went out after him to such an extent. He had a voting rights case and a gay marriage case. And they went after him that after our decision came down, he took senior status and basically retired. That's chilling.
Thank you, Ramona.
You bet.
Ramona Hage, Morris.